fun venue.
Welcome back. So just a quick rundown for this week. So we are finishing our discussion of venue today, and then we'll talk about the form of nonconvenience. And then on Tuesday, you don't have a homework assignment. I hate saying homework because you're not in like college, but you don't have a reading assignment. Because what I want you to do is to go back and review everything you have covered thus far with respect to personal jurisdiction. So the different types of personal jurisdiction, long-arm statute, and so what I'm going to do is send you a what I like to call a personal assessment. I don't like to say it's a practice question because people get all wowed out by it, but it's just assessing how well you are able to pull all the materials together, meaning how well do you understand it. So a lot of times you might not understand it as well as you think you do. So I'd like to give you the opportunity to evaluate that before we move on to subject matter jurisdiction. So it's kind of like it's not graded, but I'll have a model answer. We'll go over it together in class. I just want to make sure that you know what we're doing. So any questions, and that'll be Tuesday. It takes an hour, well, you're given allotted an hour and 15 minutes to do the practice question assessment, and so I'm going to have you do that on your own time, so we won't physically meet on Tuesday, but because you're doing the assessment, I'll need you to at least turn in what you've done to me, to the LRC, anytime next week, just so I can use it for attendance purposes. And I'll basically go through them, and if I see any major red flags, I'll ask you to meet with me. Again, I'll still give you the model answer, but if I see someone I'm concerned about, and of course you're not required to meet, but I'll at least reach out and try to get you to come and meet with me so we can sort the puzzle out. Okay? All right. Is it me or was it flurrying this morning?
Yeah.
That wasn't in the forecast, right?
I just quit.
I'm like okay, because I'm like a weather junkie, so I used to want to be, when I was in college, I originally went to school to be a weather person. I can see it. Thank you, because I thought I could do it, you know? And I thought I had the personality to be like a funny, like cool weather person. So I took meteorology because it's required. And what do you think I got in that class?
A.
B.
D minus. Okay, so really the professor liked me, and I just think he didn't want to fail me, because basically that's failing. It was so freaking hard. Because I'm like, how hard is meteorology, right? So I just thought you got to like put on a cute outfit, talk about the weather. I didn't understand that they're actually scientists. Who just happen to be good-looking people, right? So, and I don't hate science, but I'm not passionate about science, nor did I like it in high school. And so I didn't realize how much science was involved, and I just bombed it. And so then I had this crappy D minus on my transcript. So Florida State has a forgiveness policy, which is rare. I don't even know if they still have it, but you can retake 2 classes and they'll completely wipe it off your transcript. The highest grade stands, which I think is awesome. And so I retook it with a tutor and still just got a B, like with a straight up every week tutor. That's how hard it was. So I realized that was not my calling.
I would have quit.
Race car drivers are actually engineers.
Really?
Yes, they have to be.
See, he didn't know that either. So I didn't know
I
that.
didn't know that either.
Actually,
Just people that can't ever get the forecast right are actually fine.
Yeah, you're right.
I don't know. She's
So
These guys.
just out of curiosity, before we jump into class, if you could be anything in the world besides a lawyer, what would you do?
I can't
I
tell
wonder if
you.
it's worth it.
If I tell you, I get kicked
A
out.
ballerina.
Ballerina, actress.
At this point, I would probably be traveling around the world playing with orchestras and being the star of the show.
The next chick around.
See, I love
Mob.
that. So I think what I would
Mob.
have done if I could do anything, and don't judge me, okay? I would have been a physician, and this is why. I didn't realize how much money they make. Do you guys realize how much money they make? Yes. It is incredible that these people live like this, and so.
Why do you think they say married doctor or a lawyer? Yeah.
No, it's just very doctor. Because, like literally, like ER physicians make, which blows my mind. Like their bring home, so the taxes are out, are like $38,000 a month. Like, isn't that outrageous?
Yeah, that's crazy.
That's a lot of freaking money. And then like the cardiologists and the surgeons bring home like 52, 51,000 a month. Like, what do you do with that much money?
They gotta pay off their loans. We think 3 years of loans is bad.
But even still, like that's just incredible to me. If I had known then what I know now, honestly, I would have taken the tutors. I would have gone. I would have gone to med school. That's what I
I'm
would
gonna
have
kill somebody.
But that's fine.
I'm terrible.
All right, so let's get started. Yay, we are ready to rock and roll. I am bored out of my mind. There's no college football. Golf can only watch so much. So struggling. All right, so let's start off with just a recap from last class, just to make sure you remember the highlights, okay? So last class, as you remember, we began our discussion of venue. We took a look at the rules of 1391B, which are our core venue rules. We also reviewed section 1404 and 1406A for both of those. And you use those again when you're challenging venues. So again, 1391, you're trying to establish where is the proper venue. And again, just remember, venue just means where within the state of Kentucky can I file my case? Which federal district court? Western, Eastern District, and so on. And if you don't like where the plaintiff, you're the defendant, and you don't like where the plaintiff has chosen the forum, meaning where within the state they want to file, you can challenge that through section 1404 or 1406, meaning you're either trying to get the case thrown out or transferred to a better venue, so a different federal court. I also mentioned in our online class, just a reminder, that with venue, you can only transfer within the same judicial system. So from one federal court to another federal court. You can't transfer from a federal court to a state court system. So when we talk about subject matter jurisdiction, what that tells you is whether you can file a case in state court or federal court or both. Okay, sometimes depending on the facts, you can file a case in either state court or federal court. Other times you only have one option. And so if by some chance you feel that the case should not have been filed in federal court, it didn't meet the requirements, that's when you would challenge venue as well and say, no, this should be in state court. And again, remember I said at the beginning of the semester that all of this stuff is like a big elaborate chess game. It's strategy. If I'm challenging a plaintiff who's filed a case in federal court and I want it in state court, it's because I think the state court is going to be a lot more amenable and favorable to my case because I am Comfy Cal, I'm a local business, and so I know that the judge, who's going to be a state court judge who has to be reelected, he or she's not going to want a bad reputation for letting, some city slicker from New York come in and screw my business over, right? Local businesses. So I want it in state court. So if there's a way I can challenge venue when someone has filed a case against me and trying to make me litigate that case in federal court, I'm going to use these statutes to do that, okay, these sections. How do you assess whether a plaintiff has filed their claim in the appropriate court, district court? Remember 1391B provides that three ways of deciding whether or not it's in the appropriate court. And again, when I throw out these numbers, you just Google Civil Procedure Rule 1391B and it comes up. Whatever rule you see in a case, if you Google it, it comes up. So 1391B provides one, venue is appropriate in any district where any defendant resides if all the defendants reside in the same state. So that's what we covered in the last class. So I'm not going to spend a whole lot of time on it. Plus it's in the slides that I sent you. Second, another way to satisfy venue or see if it's appropriate is venue is proper in a district where a substantial part of the events or emissions giving rise to the claims occurred, or where a substantial part of the property that is the subject of the action is located. So we're going to see that in the Piper case, right? So, if there's a plane crash and you're saying that Delta didn't do their due diligence in terms of maintenance of that plane, even though I may live in California, the crash happened in Florida. So, it makes sense that venue is probably going to be more appropriate in Florida because we're going to need our experts to go look at the plane wreckage, the people that, were eyewitnesses to the plane descending from the sky with their iPhones and, where they saw the smoke trailing from and so on. So that's a second way to establish whether or not venue is proper in the court they chose. And then lastly, Remember, section 3 is kind of like that catch-all, kind of if 1 or 2 doesn't apply, then 3 is where you go. So 3 says, when no district anywhere in the United States satisfies either of the 2 venue choices, meaning 1391 B1 or 2, venue is proper in any district in which any defendant is subject to the court's personal jurisdiction. So that just means if 1 or 2 doesn't apply, which typically is, I mentioned in our last class, is because it's someone who's an international, it's an international case. Any district where the defendant has personal jurisdiction. So say if there are 3 defendants, and Kentucky has personal jurisdiction over me, another one of the defendants is a resident of Indiana, Kentucky doesn't have jurisdiction over them, but they do have it over Indiana. You can pick either state. So that's just a catch-all that says we need to find somewhere where venue is appropriate if 1 or 2 doesn't apply. So it can be where any defendant resides. Where any defendant, where the state has personal jurisdiction over that defendant. So that means they have contacts with that state that are significant enough to justify personal jurisdiction, whether it's through general jurisdiction, substantial contacts, meaning someone from London got hurt in McDonald's. Well, obviously all 50 states, McDonald's is going to have substantial contacts through general jurisdiction because they have such a strong presence. They're essentially at home in all of the states, so you can basically pick what state you want to file a case in. Okay? So any questions about that before I move on, because I want to make sure that you understand it. All right, so how do you assess residence for the purposes of venue? Section 1391C, just a reminder, and again, we covered this in the last class, but because it was online, I just want to make sure you didn't miss anything. So again, how do you assess residence for the purposes of venue? That's based on 1391C. Essentially, you're deemed to reside in any district where you're domiciled, okay, where you're domiciled. A business entities are deemed to reside in any district where the corporation would be subject to personal jurisdiction. So again, if you're a person, if you're trying to figure out where you reside for venue purposes, meaning do all 3 defendants reside in Kentucky, you're going to look at where they're domiciled. And again, I mentioned domiciled is their place of abode. And again, I mentioned that can be tricky, but you're going to look at the facts and say, Professor McNeil works in Kentucky. She has a home in Kentucky. She has a Kentucky driver's license. So you're making your argument why I'm domiciled here in Kentucky. So again, that's one of the ways you determine residence, looking at those types of factors. What address do they use when they file their taxes? I mentioned as well. But for businesses, it's any district where they're subject to personal jurisdiction. Okay. And so, what if you're dealing with a defendant that does not reside in the United States, including a defendant who's not legal in the United States? Where can they be sued? And essentially, any defendant not residing in the U.S. may be sued, just like the catch-all, in any judicial district in the U.S. So, it's pretty much, the sky is yours if you are not residing in the U.S. and you're not a citizen. You can just pick a district, okay? How can the defendant challenge venue? I mentioned they can file a Rule 12 motion and say, I want to challenge venue because it's improper. And so we'll spend a whole class on Rule 12 motions, but essentially there's a document that all the law firms have, their motions, and you kind of fill in the blank why it's improper venue, and then you file that motion with the court. You'll show up for a hearing, and you'll kind of do your oral arguments based on the written motions with the judge and say, this is why this venue is improper, Your Honor, blah, blah, blah. The other side will say, the plaintiff, no, I picked this venue because of this, it is proper, and then the judge will make a decision. So that's essentially how you challenge venue. So you either file that Rule 12 motion, or as a defendant in response, when you respond to the complaint, the charges that have been alleged against you, and again, we'll talk about that further down, you can challenge venue there as well. So you can either do it by motion or challenge it in your answer to the complaint that was filed against you. And when you're answering to a complaint that's filed against you, essentially they're saying you were committed negligence by McDonald's by not properly keeping the floor dry and safe, and in your response to the original complaint, when you're served with process with that complaint, your lawyer's gonna say, no, this isn't true. You know, the area was clean. Actually, we have eyewitnesses that will attest that we saw the plaintiff pour their soda on the floor and then proceed to fall, right? So we're basically being set up. And so in that response to the complaint, you can challenge venue. The reason I use that example is I mentioned earlier in class we had that neighbor in California that made a living off of intentionally falling. She would see a yellow thing. She would like literally scope the grocery stores where they put up the yellow caution thing, and she would move it and then fall. And then say she had to go to the chiropractor.
I'm just curious, I don't think it's related, but would the defense be able to bring up the fact that she'd been involved in like
Multiple lawsuits,
Yeah.
absolutely. But even if you have, you know, it's a character issue. But you know, when you've got and there's so many shady doctors that will, you know, service because they get paid to come in as a witness, expert witness, and say, oh yeah, her injuries are pretty extensive when they're not. But yeah, she drove a really nice car. I was really envious of her. So I'm like, she doesn't even work, Mom. It's not fair. And her kids have this. And my mom was just like, she'll get hers, but I never saw it. I just saw her living a life. You know, parents, like when people cheat, like if you're on a sports team, you're like, they totally, and they'll be like, oh, they'll get theirs. That's not really true. It's not when you think about it. I feel like they totally cheated, but it's okay. She cheated. And I mentioned too, I just want to make sure because it's important, and I promise you I will ask you this on the exam. I tell everybody this every year, and still not everybody gets it right. Let me tell you again. I'm going to ask you the difference between section 1404 and 1406 because you need to know the difference between the two. So just as a reminder, 1404, and again you're trying to transfer venue, right? You're challenging venue. 1404 applies when the plaintiff has filed a claim in the correct forum, so they're in the correct forum, right? And it only permits transfer for the convenience of the parties or in the interest of justice. So again, 1404A, the original venue chosen was proper, meaning was proper based on 1391, but the court will transfer for the convenience of the parties and witnesses or in the interest of justice. The key is 1404A only allows for transfers, not dismissals. So you can transfer from the Western District of Kentucky to the Eastern District of Kentucky, but you cannot get the case dismissed and thrown out. And again, in making that decision, the judge will look at where is the evidence located, where did the accident occur, or the harm occur. It could be a breach of contract. So they'll look at all the factors, but again, it's basically for the convenience of the parties or if it's in the interest of justice, and you cannot have the case dismissed. 1406 applies when the plaintiff chose the wrong venue from the beginning. So because they chose the wrong venue from the beginning, 1406A allows the judge to either say, you know what, improper venue, you should have known this is obvious. I'm going to dismiss your case. You can go file the paperwork all over again, and you can explain to your client why there's additional fees to start this process all over again. Or you can eat the cost yourself, but this is ridiculous. I'm dismissing the case. Or they can say, oh, you know, I'm going to go ahead, I'm going to be nice, and then transfer it to the proper venue. So you're not at risk of having your case dismissed under 1404A, but you are under 1406A. All right. So I believe we did not. Yes.
For 1404, is it that both are agreeing to the transfer as well, or is it just like one says it's more convenient and
No.
they're asking?
No, because remember the plaintiff initially they're going to pick what venue they think is best for them. So they don't want to transfer the case.
Okay.
So it's the defendant that's doing it. Now, there is a rule that says if they both agree, all parties, after the case is filed and transfer the case, that they can, without the judge intervention. But it has to be done within a certain number of days of the complaint being filed. But that's when we get later down the line. Okay, yes.
For 1404A, like the defendant wants to transfer out of convenience, but I've also read that it has to be like the venue that they're at that's appropriate is like unconstitutionally harsh towards the defendant. How would we know that in like a fact pattern?
where did you read unconstitutionally harsh? That's a very strong term. Is it a note?
Just out of like Piper, that
I mean, you don't have to find it, but literally, but so on Piper, so that was based on 1404?
yeah, that because Scotland has a judicial system, like they can transfer it, and that's not like.
Yeah, so your question,
unconstitutionally hard.
great question. So your question with respect to it has to be, reach that constitutional level of scrutiny. It's really just the judge's assessment on fairness. It just goes back to that fairness prong, and it's subjective. So when you say how would you know, there's not really a way for you to know. It's just depending on which side you're arguing for, you're going to make that argument. But there's not they don't have a standard or criteria in place like with the international shoe case. We know these factors are what are considered. There's not a framework in place to guide you, unfortunately. I'm sorry. But a great question. Anyone else? All right, so let's do the Thompson case. Yay. And we will do. Where are we here? Attorney Platt, have I called on you already? All right, lucky. Cole, Kelsey. Yay, all right, so you're done. And then your co-counsel can be Mr. Cannon, are you here?
Yes.
Hi. All right. No, so stay down. All right, cool. How did you go on, or you just raise your hand a lot?
Nah, just raise my hand.
Like, how did you go on? I forgot that quick. I called on Kelsey, right? Is it Cole? Is it pronounced Cole?
Yeah.
Okay, just making sure I'm screwing through. All right, can you give me the facts, Kelsey, for the Thompson case, please?
So the plaintiff purchased a ticket from Pensacola, Florida to Mississippi.
Uh-huh.
And the ticket provided that he would arrive at 5:05, and they left, and he took a nap and then missed his transfer. So then he is suing the bus company for not getting to where he needed because he missed court and got into trouble.
Okay, so when you saw these facts, what were you thinking?
He is a loser.
And I appreciate her honesty, because every time I see this case, I'm like, really? So you fell asleep and you're suing the bus company? Like, you really, for a bus ticket, it probably cost you, like, what, $80? Like, is that worth attorney fee? Like, what is this guy doing? So, yeah, so he purchased this Greyhound ticket from Florida to Tunica, Mississippi. Who's rode Greyhound at some point in their lives? Only a few. Poor souls. So I used to ride Greyhound before I got my first car, and when I got my first car, I said, I don't care if I have to walk from here on, I will never get on Greyhound again. The bathrooms are always disgusting, and I always have creepy people sit by me that want their breathing on me, they have poor hygiene, they want to talk to me, and I'm just like, leave me alone. I hate Greyhound. I used to take it from Tallahassee to visit my family in Orlando. I hated Greyhound. Hate it. But anywho, so we know that he's on Greyhound. As she stated, Attorney Cole, and Greyhound bus delivered the plaintiff from Pensacola to Mobile, Alabama, just after midnight. 7 hours later, Greyhound personnel directed the plaintiff to board the Colonial Trailway bus, which is what he's upset about. And so the driver, defendant Terry Reeves, announced that the bus was traveling only to Jackson, Mississippi, and therefore return to Mobile, and that a bus would depart for Jackson, Mississippi at 12:30 p.m. and arrive in Tunica, Mississippi at 5:05. But as Attorney Cole said, the plaintiff took a nap. So when the plaintiff woke up, he realized it was 2:30 p.m. and the bus was already headed back to Mobile. So the plaintiff had to wait 9 hours, which is pretty significant, in Mobile until his brother sent him a ticket back to Pensacola. So the plaintiff then missed his court date and was found guilty of abstention. So The plaintiff uses Greyhound, Colonial Trailways, and Reeves on several state law causes of action, meaning he files claims. And he says, yes, this case should be in this federal court because I have subject matter jurisdiction based on diversity. And although we haven't covered subject matter jurisdiction, again, it just means that the plaintiff and the defendant are domiciled in different states, right? And so he's like, I can have this case in federal court. So attorney, wow, Cannon,
Yes.
what's the issue in this case? Why are we even here?
So Greyhound moves to dismiss because they say that he failed to state a claim and that they don't, that it was the improper venue.
Excellent. Okay, so you have a situation here where the defendant, Greyhound, is saying, hey, he picked the wrong venue. This is an improper venue, as well as failure to state a claim. So we'll talk about that later on too. But failure to state a claim typically is when you feel like the plaintiff's claim of what they're alleging isn't adequate, meaning it's not, like, this is kind of a goofy claim. Oh, I overslept, and I want to sue you because I overslept. Like, they're like, this isn't even a legitimate claim, essentially, right? So who has the burden then, Attorney Cole, of proving that this is the correct venue?
The burden is on the plaintiff.
Okay, and they're going to do that under 1391B, right?
Correct.
Okay, so again, the court essentially says that Greyhound, they criticize Greyhound for not requesting an evidentiary hearing. The plaintiff needed only to establish a prima facie case showing a venue. Because the Greyhound failed to request an evidentiary hearing, the court's review is very limited in this complaint because neither party presented affidavits or evidence to support whether venue was proper or not proper. So we know that the court concludes that the plaintiff has not met the standard for proper venue under, again, 1391B. Why does the plaintiff lose under 1391B, Attorney Cole?
Because they
Well,
filed.
B1 rather. Why does B1 not apply? I apologize.
Because he was a citizen of Florida, so he didn't qualify for the residency.
Okay, so where were the other defendants residents of? Or can you tell me where the plaintiff brought the suit at?
They brought it in the place where the transfer should have happened,
And which state was that?
Alabama.
Yeah, excellent. Southern District of Alabama. So we know, remember 1391B1 tells us what? What was that rule?
That you can have a venue where any defendant is resident in that state.
Excellent. So 1391B1, remember, venue is proper in any judicial district in which any defendant resides if all defendants reside in the state in which the district is located. So all individuals reside in the U.S. district in which, again, that person is domiciled. We know the plaintiff brought the suit in the Southern District of Alabama, right? Reeves, as she stated, is a citizen of Florida, and his domicile residence is the state of Florida. So because of that, obviously, you cannot bring that suit based on 1391B1 in the state of Alabama. Now, if he was a resident of the state of Alabama or domiciled in the state of Alabama, as well as the other defendants, then yes, you could bring a suit there. But again, because Reeves does not reside in Alabama, it's not proper venue under 1391B1. Attorney Cannon, what does the court say about the second option, 1391B2?
Okay, so that one's if a substantial part of the events that give rise to the suit happened there, they kind of, I think, brushed that one aside because weren't they just like, well, you just changed buses there, so that's not enough to qualify as substantial.
Do you agree with that?
It's kind of hard to separate your opinion of like this guy's behavior
I know, from the facts.
from the facts, but
Wait till you see the Chiquita banana
if-
case.
yeah,
It's really bad.
I feel like, as dumb as it sounds, I mean, that's kind of the basis of the claim is that he missed the transfer there. So I guess I don't agree with it now, not in this case.
What do you think, Attorney Cole?
I think that it does have more to do with where he purchased the ticket because, I mean, they didn't have a duty to wake him up or do anything at that bus stop. So where they have the contact, I feel like, to be where they have the meeting.
Okay, but can you see the difference in how you would argue both? Because in one sense, I think Attorney Cannon's argument is very strong, because when I see this case, I'm like, that's where the breach allegedly occurred, or the incident, was during that transfer. Yeah.
Well, wasn't that where he started, but then the failed transfer was in Jackson, Mississippi? Not in
But still,
Mobile?
that's where he fell asleep.
Do we know where the nap started?
I do.
If it crossed into Mississippi.
Right. Good point. So we know that the only event that occurred, based on the court's assessment in the Southern District of Alabama, was again that the plaintiff changed planes there, and that the event did not directly, according to the court, give rise to the claim. It wasn't alleged that the bus transfer led to a breach of contract, right? Greyhound's negligence and breach of contract arise from the failure to drive safely and successfully transport the plaintiff from to Tunica, Mississippi. So the way the court saw it is that the plaintiff entered into a contract essentially with Greyhound to get him to Tunica, Mississippi by 5 p.m. on March 15th. And taking the Colonial Trailways but to Jackson would have gotten him there at the time again, but he fell asleep. So just because he passed through the Southern District of Alabama forum and changed buses there, the court said, doesn't mean the claim necessarily arises out of that venue. But the court does something interesting in this case, right? Instead of dismissing the case, they transfer. Do you think they should have dismissed the case, Attorney Cannon?
No, I mean, why not let it run its course? Like, I think they're probably pretty confident that it's gonna get dismissed somewhere along the line, but they're like,
So why not now? That's my point.
well, I don't know. I mean, like, you've got this prong system set up. If you start messing with it, then, you know, like, just for the sake of it, because, yeah, it's silly.
It's
in
frivolous,
this
but
certain-
this is why our court docket gets overloaded for goofy stuff like this.
Yeah, I know that's a good argument, but I'm in favor of just letting it run its course so you don't have to start tinkering with it. It's kind of like what we talked about with, like, the O'Connor versus that other test. Like,
Brennan.
yeah, just like let it run its course, and you've always got that fairness prong to back it up if you get there, but you don't need to, like, cut it out in the beginning, I don't think.
So you represent, and then I'll get your question, 50% of our faculty. So we sit every year and debate in faculty meetings about process. And how important it is to go through the process. And so some of us feel like, why are we, like, let's just vote. Like, we'll have an issue. Why can't we just vote on the issue? We know we have the overwhelming majority. We know it's going to pass. Let's just vote on this new initiative.